Hello again. So what we're going to do now is we're going to take a look at, six or so cases, kind of right back to back, that deal with the constitutionality of some of these cases. Oh, we're going to do that. The first case we're going to take a look at is this, and they all. One of the things that's important to keep in mind about this is all of these are dealing with something that is justiciable. We're not talking about sort of a mental concept of privacy. We're talking about something that is legal and how laws have drawn the boundary between private and public and what is legal and what is not. All right, so we're going to take a look at one of the ways that those come in contact with each other. The friction between those two spheres oftentimes has to do with criminal law. So the first case, and again, some of you might know this if you're criminal justice majors. You might know some of these cases. I'm just giving you kind of the cream of the crop, like some of the most leading cases related to this. A good place to start is Mapp versus Ohio. And in Mapp versus Ohio, one of the interesting issues was there's a man who was suspected of a particular crime. The police officers came to his home, and he was not there, but his wife was there. And this suspect's wife allowed them in. Some of the police officers came in and waited for him to arrive. The rest went and got a warrant, and they were waiting to serve the warrant to him and arrest him. And so after he showed up, they arrested him, and they started to conduct a search of his home. Now, this was not on the warrant, but it was within the home, and they were gathering evidence against this person. So eventually, this was went to trial, was appealed, and went all the way to the Supreme Court. And so one of the questions that the Supreme Court was dealing with in 1961 was, is the evidence obtained in that situation a violation of the Fourth Amendment? And is that admissible in court? Remember, we were looking at the exclusionary rule before. They found in 1961, no, that's not a violation, that's not admissible in court. So it is excluded. But why? So again, I want to point out that the exclusionary rule does have some tweaks to it. There are some situations in which evidence that's obtained in searching someone's home without a warrant can be used. But you'd have to look at some of this, the granular level of some of those things. In general, though, what happened in 1961 was that the opinion of the court was that the Due Process Clause of the 14th Amendment applies the Fourth Amendment prohibitions against unreasonable searches and seizures to all the states. And here again, yet again, is this idea of using the 14th Amendment to not just talk about federal cases, but state cases as well. So basically it applies these principles of the Bill of Rights to basically all situations. So therefore the exclusionary rule applies to the states, and this is a term that we call incorporation. So sometimes it's called selective incorporation, depending on how it's applied, but it's a Supreme Court concept or a legal concept that means applying the parts of the Bill of Rights to the states. So basically what came out of that is this idea that a police officer cannot come into one's home, even if they have a search warrant. By the way, there's search warrants and there are arrest warrants, but they can't come into one's home and search indiscriminately. There has to be some specific probable cause to search in certain areas. And again, there's some exceptions to that. And then we get to these are such interesting cases. We get to this case in 1986, in which there's a person in California who was suspected of growing their own marijuana, which was illegal the way it would have been done at that time. So in their own home, in their backyard, and as you might see here in this picture. And so the question is, how do you get information about that to get a warrant? So if it's a whiff of a hint, that's not good enough. So how do you get information so that you can get a warrant, so you get a probable cause? So that's kind of what happened. the law enforcement officers investigating this, I believe they chartered a small craft plane, flew over, and took shots of this and looked down in this person's backyard. There's a fence around it, and used that as evidence against this person. So the question that eventually got to the Supreme Court in 1986 was, is a warrantless aerial observation to obtain a warrant a violation of the Fourth Amendment? So, right, so that's basically obtaining information, maybe even evidence, ultimately what became evidence, without a search warrant, right? So they said no in that particular case. So pay attention to why. They said that really there's a reasonable expectation of privacy in someone's home. Again, this goes back to this concept we have, kind of more of a mental concept than it is maybe even a legal concept, that there's certain areas of a home that are pretty protected. They should be private. They're not, you don't act the same way in your bedroom as you would out on the street, probably, they say. And there's an expectation that you shall not be invaded through surveillance technologies. Now, that's kind of a concept that helps guide this opinion. But they also said this: the Fourth Amendment never requires police to, quote, shield their eyes from information available to the public or in plain view. So if anyone could charter a plane, theoretically, fly over and look into someone else's backyard, then law enforcement can do that as well. Which is an interesting question when we talk about drones. Like, this is the next wave of this. You might have a drone, you can fly it over someone's home, and so what one of the questions is, can you do that? Can you invade someone's home? Can you go into the house with your drone? And if you can legally, then why would the police be prohibited from doing that? And the answer, by the way, is we're still working that out, but that is an invasion of someone's privacy. So we go to another case, another fascinating case here. California versus Greenway. I just love this case. I just find it so interesting. So again, there was a person suspected of dealing with drugs, or I can't recall if it was dealing with drugs or formulating drugs in their home. In any case, they were using a single family home in California to process and if I can recall correctly, organize the sale of certain drugs. And so what happened is they were throwing out this drug paraphernalia at a curbside pickup like this. They bagged it up, sealed it, and would bring it out just before the garbage was supposed to be taken away on garbage day. All right, you're following me so far? So what happened was, the police officers, being very smart, they asked the garbage pickup company to clean out their garbage before they picked this garbage up from this particular residence. So they knew it would be basically clean, or at least devoid of any other material. Pick up the garbage as they normally would, take it around the corner, and then allow the police to look at that, right? So there's no warrant. They're not invading anyone's home. So eventually, again, this got appealed. This did go to court and was appealed and went all the way to the Supreme Court. So the question is, does the Fourth Amendment prohibit a warrantless seizure of garbage left for pickup? Remember, the Fourth Amendment prohibits warrantless seizure of material that would be used as evidence against someone. Is that a warrantless seizure? So in this particular case, and I'm simplifying all these, by the way. There's obviously you know this. There's a lot more to them. I'm just giving you some of the highlights. The court said no. That's not the Constitution does not prohibit that kind of situation. But why? Again, it goes back to this belief that we have in private property, but also the boundary. Where is the boundary? They said that when you take garbage to the curb, you're not only literally taking it outside of your property, but you're also demonstrating that you're done with this material. And so that's a reasonable thing to consider when someone puts garbage in a garbage container at the edge. So reasonably speaking, it's outside the curtilage. So you're pretty good there, they said. But also it's common knowledge that garbage being left for pickup is going to be taken away. And then there's this interesting thing, the inevitable discovery exception. So will it inevitably be discovered or not is something that some legal people deal with, and also law enforcement. So anyway, that's kind of an interesting. So I'll add a question to this: where would the material have to be on someone's property for it to be off guard or off limits? How close to that building would it have to be? How what's the manner in which it's concealed? Is it 10 feet away from the curb? Is it kind of has it been opened up by dog or some someone rummaging through? These are interesting questions. So this brings us to Schimmel versus California, another of several California cases, pretty famous and well known. This is another situation in which a person was suspected of burglarizing, and there was this warrantless search of the entire house. And you might guess that the answer to this question was if that information, that evidence was eventually brought as evidence and led to the arrest of this person, does a warrantless search of that house, is that allowed? And they said no in 1969. They said it's unreasonable. You, again, have to have a warrant with specifics. Again, some exceptions to that. They didn't meet the exceptions here. And they quote the Fourth Amendment, particularly describing the place to be searched and the persons or things to be seized. So what came out of the Schimmel case is that there's this idea of the boundaries when someone is investigating someone's home. There's the suspect, like where they are, plus the area under immediate control or personal purview. So they can look around, but they can't stomp around. They can't probe without sticking to that warrant and where that warrant specifies they should search. Another case from New York City. This time from New York City. Let's see. Yeah, this was a suspect of murder, and while this person was gone from their home, the police officers, the detectives, went into this person's home without a warrant, and they were searching and they gathered information. They didn't. I believe the person that did let them in objected, and they eventually used this as evidence. And so that, as you might expect, clearly is a violation, even though the laws of New York allowed for that. So basically what that did is it said that law was unconstitutional. So in the simple language of the Fourth Amendment, even if there is probable cause, consent or warrant must be granted. You have to allow that. And again, think of what's at stake here, this basic principle that goes back hundreds of years, that your home is your castle. There are exceptions. The exigent circumstances are if there's a probable cause that person, that suspect is in there and someone's going to be harmed, or some evidence is going to be immediately destroyed, there might be a situation in which someone can be a law officer can invade. But again, those are exceptions. Also, U.S. versus Ross. This is an interesting one too, out of which we get just a slew of cases dealing with the issues with pulling someone over with a car, being suspected of committing a crime or being involved in a crime or having evidence. In this particular case, the suspect, when pulled over, had there was a bullet found on the passenger seat, and so the police officers searched the glove compartment, found evidence, and then searched the trunk and found a paper bag full of, I think it was heroin, and so this person that was used against them. So can the police conduct a probing search of a car if probable cause exists? And they said yes. So what's interesting about this case is, and maybe we're all familiar with this, is it's not a house, right? It's your property, but it's not a house. So that's an interesting thing. We're far away from what the Constitution has literally said, and we're at sort of how this might be applied in everyday life. So, but the important principle about this one is that the warrant granting in that particular case, when a car is pulled over, is not logistically possible in all circumstances, if probable cause exists. The same objective facts that would allow a court-issued grant must be used. So you have to use the scrutiny of what a judge might use in that situation. If the judge would have said, yes, that's probable cause, then you might be able to go ahead and search, even though it's not someone's property. Okay? We'll see you at the next one.